All right, get ready to dive deep because today it's all about deeds. You know those documents, right? The ones that determine who owns what property. Well, we were given this document breaking down all the different types of deeds. And let me tell you, it's way more fascinating than you might think.
Yeah, it's easy to dismiss them as just paperwork.
Right.
But honestly, deeds are the foundation of property ownership, and the type of deed can significantly impact your rights.
And protection, right.
Absolutely.
So it's almost like the deed is the instruction manual for how ownership works on a specific piece of land.
That's a great way to put it, yeah. And there are different versions of this manual, offering varying levels of security and risk, depending on the type.
Okay, so you're already making me rethink everything I thought I knew about deeds. Let's start with the ultimate, most secure type of deed. What would that be?
The top tier. That would be the general warranty deed. It's the gold standard because it offers the most buyer protection. The seller, known as the grantor, is essentially saying, hey, I have a clear title to this property and I guarantee it goes back forever. No hidden claims, nothing.
Forever? Wait, so they're saying there's no chance of some surprise claim from way back in history popping up?
That's the promise, which is why buyers love general warranty deeds. But for the grantor, it's a big risk.
Makes sense.
Imagine someone comes along with a claim from, 100 years ago.
Oh, wow.
The grantor would be on the hook to handle that, which could get expensive and time-consuming.
So it's not a decision grantors take lightly.
No, not.
I'm starting to see that. So in what situations might someone use a different type of deed, one that maybe offers a bit less protection, but also less risk for them?
Well, let's talk about the special warranty deed. This one's a bit more limited. The grantor only guarantees a clear title for the time they own the property. So they're saying, look, everything was clear while I owned it, but I can't speak for what happened before that.
Oh, okay.
Yeah.
So that seems more realistic, especially if you've only owned the property for a short time or if you inherited it, for example.
Right, exactly.
What other kinds of deeds are out there?
Let's see. We have the bargain and sale deed. This one is way more basic. The grantor implies they have some ownership, but they don't actually guarantee a clear title.
So it's kind of like buyer beware.
Kind of. Think of it like buying something at a flea market. You're taking a chance on what you're getting.
So would you always recommend doing a title search in that case, just to be safe?
100%. With a bargain and sale deed, it's crucial to do your homework, uncover any potential issues before you commit.
Makes sense. Now, there's also the Quitclaim Deed, which, to be honest, sounds a little scary.
Yeah, a little bit, right.
What's the deal with that one?
The Quitclaim Deed is basically the whatever I've got, you get, but no promises deed. It's often used within families or to clear up title issues.
So like transferring property to a relative or maybe resolving a boundary dispute with a neighbor.
Exactly. But here's the thing. The grantor isn't actually confirming they have a valid ownership to transfer. They're just handing over whatever interest they might have, which could be nothing.
Oh, wow.
Yeah. So it's like the wild card of deeds.
Definitely sounds like you need to be extra careful with those.
Absolutely. Quitclaim deeds can be useful, but you really need to know what you're getting into.
We've covered the four main types of deeds, but, the document you gave us also mentions some more, shall we say, unique ones. Things like sheriff's deeds or trustees' deeds.
Oh, right. Yeah. Those usually come into play in specific situations like foreclosures, tax sales, or auctions.
So if you were thinking about buying a property and you saw one of those in the deed history, would that be a red flag? Like something to look into further?
Definitely. It doesn't automatically mean there's a problem, but it would be wise to investigate further.
So it's like a clue that there might be more to the story of that property.
Exactly. Something out of the ordinary happened with the ownership.
All right, so we've explored the different types of deeds, but what about the actual document itself? Like, what makes a deed legally binding? What needs to be included?
Oh, there are key elements that every valid deed needs to have. First and foremost, it has to be in writing. No verbal agreements or handshake deals when it comes to real estate. It also needs to clearly identify both the grantor, the person transferring the property, and the grantee, the person receiving it, with accurate names spelled correctly and matching any previous records.
So no nicknames or creative spellings allowed?
Nope. Everything has to be official and consistent.
Makes sense. What else is essential?
Even if the property is a gift, the deed needs to state some kind of consideration. Even a small amount, like $1, just to show that something of value was exchanged. And of course, it needs a very specific, detailed legal description of the property, usually referencing those plat maps or survey systems we talked about.
So nothing vague like that cute little house with the blue door.
Haha, no. It has to be precise and legally unambiguous, leaving no room for doubt about exactly what property is being transferred.
Wow, I'm realizing how much I took these details for granted. All these elements that come together to make a deed legally sound. I never really thought about it before.
It's easy to overlook the finer points, but they're crucial to ensure a smooth transfer of ownership and prevent any future disputes.
This is really making me appreciate the role of lawyers in real estate.
Yes, they definitely have their place.
It seems like it. But even for those of us who aren't legal experts, just understanding the basics of deeds is empowering. It helps you ask the right questions and make informed decisions about property.
I totally agree. It's all about having that awareness and knowing what to look out for.
Absolutely. This has been fascinating. We've covered those key types of deeds, the elements that make a deed valid, and some potential pitfalls to avoid. But there's still so much more to explore. We've only just scratched the surface of this deed deep dive.
Welcome back. We're in the middle of this deed deep dive, and it's amazing how many little things have to be just right to make sure a deed is valid. Makes you wonder, what are some common mistakes people make with these documents? Like, what trips people up?
Oh, you'd be surprised. Even tiny errors can cause huge headaches down the road. One of the biggest culprits. Messing up names, misspelling a name or not having it match exactly with other official records. They can really throw a wrench in the works.
So it's not just typos, it's about being totally consistent across all the paperwork.
Exactly. The legal name on a deed has to be a perfect match. Even if there was a mistake on a previous document, you have to get it right this time.
So you can't just use a nickname or a shortened version of your name. Nope. Got to stick to the official records. Another common trap is a vague or inaccurate property description. Remember those super specific descriptions with the plat maps and survey systems?
Oh, yeah.
You can't get poetic there. It has to be precise. No room for interpretation.
Makes sense. Otherwise, you could end up with boundary disputes with your neighbors.
Exactly. And those can get ugly, not to mention expensive.
Okay, so names, descriptions, those are crucial. What else should we be watching out for?
Missing signatures. Seems obvious, right? But you'd be amazed how often it happens. Both the grantor, that's the person transferring the property.
Right.
And in some cases, the grantee, the person receiving it, need to sign for it to be official. And those signatures have to be on the right lines in the right places.
Wait, so the grantee has to sign sometimes too. I always thought it was just the person selling or giving the property who had to sign.
Well, it depends on the state and the specific type of deed, but often both signatures are required to make it a done deal.
Interesting. What about that whole notary thing we talked about before? Is that just a formality or is it really important?
It might technically be valid without a notary, but almost always you'll need that notary seal to record the deed.
Which is super important.
Right. Most counties won't even look at a deed without that official stamp of approval.
So it's like the notary is confirming everything is legit.
Exactly. They're vouching for the signatures, making sure it's all above board.
Okay, so we've got accurate names, super clear legal descriptions, all the signatures are in place, the notary has given it the thumbs up. Anything else? Any other hidden traps we should be aware of?
Honestly, it's always smart to have a pro look things over before you sign and record anything. A real estate attorney or a title company.
Oh yeah, good point.
They can spot any potential issues that you might have missed.
Worth the peace of mind, probably.
Definitely worth it, especially considering the potential problems it could prevent.
Now, you mentioned earlier that for a deed to be valid, the grantor has to be of legal age and of sound mind. What happens if someone tries to transfer property when they're, not mentally capable of making those decisions?
That's a great question, and it can get pretty complicated. But basically, if someone challenges the deed and it turns out the grantor wasn't capable of understanding what they were signing, the whole thing could be voided.
Wow.
Yeah, so it's not just about age, it's about mental capacity, being able to make informed choices about your property.
That makes sense. We were talking about serious legal stuff here.
Exactly. And that reminds me, this document also mentions something called a power of attorney.
Oh, right. That sounds like it lets someone else act on your behalf.
It does. A power of attorney is basically a legal document that gives someone else, the attorney, in fact, the authority to handle your affairs, including signing legal documents like deeds.
So, for instance, if you were, say, out of the country and needed to sell a property,
right,
you could give someone power of attorney to handle all that for you.
Exactly. But, powers of attorney can be really specific or super broad.
How so?
You can grant someone the power to handle just one transaction, or you could give them much wider powers to manage lots of things.
So it's important to be very clear about what you're allowing them to do when you set up a power of attorney.
Absolutely. It's a powerful tool, so you've got to use it carefully and make sure you trust the person you're giving that power to.
This is a lot to take in, honestly. Deeds, legal jargon, powers of attorney. It's fascinating stuff, but there's definitely a lot to think about.
I agree. Deeds might seem like just pieces of paper, but they're really the foundation of property ownership. They can have a huge impact on people's lives,
Definitely. You've opened my eyes to how important it is to understand these documents.
Glad to hear it.
Now, before we wrap things up, I want to revisit those race notice statutes we touched on earlier. Those sound like they could really shake things up when it comes to property ownership. Welcome back to the deep dive. We've spent this episode exploring deeds, and I have to say I'm feeling way more knowledgeable about all this than I did before. It's amazing how something that seems so basic at first glance actually has so many layers.
Yeah, I agree. Deeds often get overlooked until something goes wrong, that is.
Right, exactly. And that's why we're doing this deep dive, to help people understand their rights and, avoid those potential pitfalls.
Absolutely.
Now, before we wrap up, I wanted to go back to those race notice statutes we touched on before. They sound like they add a whole other level of complexity to property ownership. Can you break those down for us?
Sure. So race notice statutes, they essentially say that if there are multiple claims on a property, the person who records their deed first wins. But there's a catch.
Okay, I figured there would be a catch.
They also have to be what's called a bona fide purchaser.
Okay, bona fide purchaser. I'm going to need that translated into plain English.
Haha. Okay. So that means they bought the property in good faith, paid fair market value, and had no idea about any other claims on the property. Like, imagine you bought a car and then later found out it was stolen.
Ooh.
But you bought it without knowing you acted in good faith. That makes you a bona fide purchaser.
Oh, okay.
So even though the seller didn't have the right to sell it, you're protected.
So bringing that back to property, if someone buys a place, but they don't know there's like a hidden claim on it, they're protected as long as they record their deed first.
That's the key. They have to be the first to record, and they have to meet those bona fide purchaser requirements. That's why it's so important to record your deed as soon as possible. If you wait, someone else could sneak in and record theirs first, even if their claim isn't legit.
Wow, okay. Yeah, definitely don't want to procrastinate on that paperwork. Now, while we're on the topic of ownership, I also wanted to touch on the different ways someone can actually hold title to a property.
Yeah.
You mentioned sole ownership, joint ownership, corporations, trusts. It seems like there are a lot of options.
Yeah, there are quite a few ways to structure it. And how you hold title can have big legal and financial consequences.
Let's start with the most basic, sole ownership. What does that mean?
So sole ownership, sometimes called ownership in severalty, it's pretty straightforward. One person owns the property outright. They make all the decisions, enjoy all the benefits, but they're also responsible for everything. Costs, maintenance, you name it.
So it's like ultimate freedom and control, but also ultimate responsibility.
Exactly.
Okay, that makes sense. What about joint ownership? How does that work?
Joint ownership is when two or more people own a property together, but there are a few different ways to do that, each with its own set of rules.
Okay, so let's break down those different structures. What are some of the common ones?
All right, so one common form is joint tenancy. With this one, each owner has an equal share, and there's something called the right of survivorship.
Right of survivorship.
What's that? It means that if one owner dies, their share automatically goes to the surviving owner, bypassing probate. So it keeps things within the group.
Oh, I see.
It's often used by married couples or families, people who want to simplify things when someone passes away.
Yeah, that makes a lot of sense. Makes the transition smoother. Are there any other types of joint ownership?
Yeah, there's also tenancy in common. This one's a bit different. Each owner has a specific share, but there's no right of survivorship. So if one owner passes, their share is distributed based on their will or through the probate process. It doesn't automatically go to the other owner.
So more control over what happens to your portion after you're gone.
Right. It's a good option for business partners or maybe friends buying property together who want to maintain their separate interests.
Okay, that makes sense. Now, what about corporations and trusts? Where do they fit into all this?
Well, corporations can hold title to property, just like an individual can. Sometimes it's done for liability reasons, to keep the company's assets separate from the owners.
Oh, so it's like a layer of protection.
Exactly. It can also have tax benefits, but you always want to talk to a lawyer and a tax advisor, to make sure it's the right move.
Good advice. Now, trusts. Those seem pretty complicated. How do they work with property?
A trust is where a trustee holds and manages the property for someone else's benefit. It can be used for estate planning, minimizing taxes, protecting assets, things like that. There are a lot of options and ways to set them up.
Sounds like you need a professional for that.
For sure, trusts can be very complex.
Well, this has been incredibly informative. We've covered so much today. The different types of deeds, how to record them, common mistakes, even the different ways to hold title to a property. I feel like I have a much better understanding now.
That's great to hear. It's all about knowledge and awareness, especially with something as important as real estate.
Absolutely. And on that note, before we wrap up, I have a final thought for our listeners. Now that you know all about deeds, the importance of understanding them, the different types, all the elements, how might you go about investigating the deed history of your own property or a property you're thinking of buying?
That's a fantastic question. It's definitely worth looking into. You can often find those records at your local county recorder's office or sometimes even online through real estate data services.
Great advice. A good reminder that taking the time to do a little research can really pay off when it comes to property ownership.
I couldn't agree more.
And with that, we've come to the end of our deed deep dive. We hope you've enjoyed this journey into the world of real estate law and feel ready to explore the ins and outs of deeds with more confidence than ever. Thanks for joining us.